Hello and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm Matthew Bruckner, an associate professor at Howard University School of Law. My guest tonight is Sheldon Evans, an assistant professor at St. John's University School of Law, and we're going to talk tonight about his new article, Categorical Non-Uniformity. Sheldon, welcome to the podcast.
Thanks, Matt. I really appreciate the opportunity to talk about my latest piece, as you said, Categorical Non-Uniformity.
Can you tell us what is categorical non-uniformity, the article? What's your sort of thesis? What's your elevator pitch? Why should people listen to the rest of this podcast?
Yeah, so the 10,000-foot view is it's an interesting piece that melds together a number of different areas of the law. It goes through criminal sentencing. It goes through immigration law. And there's also hints of federalism in there as well. And basically what the thesis of the article is there's this thing called the categorical approach. And it's a method that federal judges use to determine if a state criminal conviction can carry a federal consequence. So a federal prison sentence or maybe a federal immigration consequence. The problem, though, is when you have 50 different states that define their criminal laws differently, that leads to different federal outcomes. So you have non-uniformity in how the categorical approach is being applied, depending on whether somebody may have a criminal conviction in California or whether somebody may have a criminal conviction from Iowa. The differences in those state laws can create differences in federal consequences. And that can be the difference between whether somebody gets deported or not deported, or whether somebody gets a longer prison sentence or a shorter prison sentence. So it's actually quite impactful in several different areas of the law. And in this paper, I've just focused on criminal sentencing and immigration, where we see that phenomena.
So that's great. So I think the article has a bunch of really good examples that the very same underlying criminal conduct, perpetuated in Iowa versus in Missouri can have dramatically different outcomes because the law in Iowa may be different from the law in Missouri, or in your example, California. And that just, you suggest is strikes at our sense of unfairness and also is antithetical to some of the rationales for this categorical approach. So could you maybe articulate what some of those are? Like why do we, you don't like this categorical approach and you want to change it. Why do we have it in the first place?
Yeah, so there's a couple of scholars that have looked at this, and there's a little bit of disagreement on who we should blame for this problem. Some scholars say that this is the fault of Congress, because Congress wrote these federal laws. And in the federal laws, it explicitly says, somebody will be deported if they commit this type of state crime. So some people say it's Congress's fault and they should fix it. I focus on the categorical approach, which is more an issue of federal judges interpreting these congressional statutes in a way that is inconsistent with the overall intent of uniformity of federal law. One of the big reasons that we have federal sentencing laws, one of the reasons that we have a federal immigration system is so that people are treated the same across all state jurisdictions. So, one of my arguments is that if you commit the same criminal conduct in two sister states, Iowa versus Missouri, they're separated by maybe a 20-minute drive, depending on where you live in those states. But there are examples of if you commit for example, a burglary in Iowa versus if you drive 20 minutes and commit that same burglary in Missouri, you will have different federal outcomes when it comes to certain federal statutes, certain federal sentencing statutes, and also in the immigration context as well. And that seems to be inconsistent with the goal, with a couple of goals. Number one, to set up a federal system of laws that has uniformity across jurisdictions. But also when we get into a little bit of punishment theory in criminal law, the kind of the notion of fairness, the notion of justice, that we are punishing people based on a certain set of actions that they have taken that has somewhat broken the social contract. Whereas under this system, where punishment is not based on the actions of an offender, which seems to comport with our notions of justice and fairness, but really punishment is based on where this person happened to be when they committed a particular crime. And so that's an inconsistency that I try to tease out in the paper. And ultimately I try to fix with some novel solutions.
So I think you do a good job of that, explaining the differences, as you did here, about the same underlying criminal conduct having different results. So that is really, though, a problem of differences across states rather than within a state, right? And
Right.
so, the very same criminal conduct without a federal enhancement might also similarly have a different sentence or punishment that carries with it in Iowa than in Missouri. And so why is it, right? So that already is the case because of our federal system. So why is it a problem that there are these federal enhancements that differ on a state-by-state basis?
Yeah, so you raise a good point about the state punishments. So if you commit let's stick with our Iowa and Missouri burglary example. If you commit a burglary in Iowa, Iowa has the sovereignty and the jurisdiction. Maybe they want to sentence you to 10 years in state prison. Do the same thing in Missouri. Missouri can sentence you to 5 years based on their law. And we all recognize that's okay because, states have the police power, especially in criminal law, to determine punishments for its citizens. Now, when you take that to the federal level, however, when two different sovereigns are punishing differently, we accept that as, like you said, a part of our federal system and sovereignty of states. But when you have one sovereign, the federal government, punishing two similar people differently, that's where I think the problem comes in. And especially when you look at some of the legislative history of the federal sentencing guidelines. And this is, the guidelines were instituted back in the 1980s. When you look at some of the reasoning behind why do we want these complicated federal sentencing guidelines, one of the reasons explicitly stated was we want it to be uniform. We want to make sure, and what does uniform mean? Well, according to the legislative history, uniformity for the most part meant we want to make sure that similar offenders and people who are committing similar conduct with some similar backgrounds are punished similarly. And it was a big concern that there was a lot of disparate sentencing, and unfortunately we still see that today. But the sentencing guidelines were meant to cut down on these disparate sentences based on kind of irrelevant differences between criminals. So my argument is, the difference between where somebody happened to commit a previous crime, whether they committed the same conduct in Iowa versus the same conduct in Missouri, that shouldn't justify the federal government treating those two offenders differently. If Iowa and Missouri separately want to give different state punishments, that's federalism. If the federal government wants to give them two different sentences, even though they committed the same conduct, just because they lived in two different states, that seems to be exactly contrary to what the federal sentencing guidelines were meant to root out over 30 years ago.
Yeah, see, as not a criminal law person, I find this fascinating. So I'm primarily a bankruptcy person, increasingly sort of consumer law and student loans. But in the bankruptcy context, it's a well-known, I was going to say problem, but issue or thing that happens that people file cases in jurisdictions where the laws, people might say well developed, but what they mean is they know what the outcome is going to be. There's judges there that will are more likely to give them the outcome they want, and of course with bankruptcy they get to choose where they file. Maybe it's not, of course, they get to choose where they file more or less. These companies, and so this issue in criminal law of trying to create national uniformity, at least from a bankruptcy lawyer, seems like a bit of a fool's errand. This idea of uniformity seems impossible to achieve, and this is something you get into in the article, right? You talk about these sort of varied and contested definitions of uniformity and about whether it's possible. So you talk a little bit more about that. You talked a little bit about the sort of the statute, but and why uniformity should be prioritized. But can you expand a little bit on what are these sort of competing notions of uniformity that exist in the scholarship and in criminal law more generally?
Sure. And I'm actually glad you brought up bankruptcy because maybe this is an opportunity for me to learn from your expertise because, like you said, bankruptcy is perhaps another example of where you have a overall federal system, and you'll have to tell me if this is right or wrong, different states define property differently, and maybe based on those state definitions, you could get more favorable, that could affect the federal outcome in a bankruptcy case.
Absolutely.
And I know that's also the case in other contexts of property when it comes to federal takings. Again, there are so many instances where the outcome of a federal case is based on the specific definitions of substantive state law. And so this is just kind of another one of those. From a really broad perspective, another one of those interactions between federal and state law that I think at least produces odd outcomes. But so let me stop being a law professor and actually answer your questions. But I do find the bankruptcy example interesting. So. One of the problems with writing an article about uniformity, and I say this in the paper, the irony of uniformity is that it's not uniform. there are different ways and different definitions of uniformity that you could think of. And this comes up in some of the scholarship as well as in some of the court cases, especially out of the Supreme Court. So one version of uniformity, the version that I think has more precedent behind it and more kind of legislative history behind it, is the a common maxim that you may have heard and other law students and professors may have heard, to treat similar cases similarly, or to treat similar offenders similarly. And there's a million different ways you can cut that. And this is why sentencing is quite complex. What does a similar case mean? Right? That could have several different aspects. That could be similar conduct. That could be similar defendants. And how do you cut that? Well, do they have the same hair? Is that relevant? Or, do they have the same educational background? Is that relevant? And so, treating similar cases similarly in and of itself is even hard to define. And I try to narrow that by saying, well, at least we should treat similar conduct similarly. Because again, if we're connecting punishment to what this person did, what was their conduct? How did it offend society that justifies the punishment? I at least think that conduct is a really important aspect of punishment. And so when we talk about treating similar cases similarly, I try to narrow that a little bit by at least saying, similar conduct should be punished similarly along that same vein. Now, another competing version of uniformity is kind of having a uniform rule that's applied the same in every case. So, and that's the argument for the current categorical approach. So you have a similar rule, same rule called the categorical approach, and you apply it the same way in every case. Now, that doesn't necessarily mean you get similar outcomes. Mm-hmm. You can still get disparate sentencing outcomes, but as long as you're applying the same rule in the same way to all cases, for some scholars and judges, that is enough to fulfill kind of this ideal of uniformity in the federal system, which I don't think is consistent with some of the sentencing goals that I mentioned before.
So that's interesting. So it's been a long time since I took legal philosophy, but that makes me really think about sort of Hart and Sachs and legal process, and which was really, ascendant, maybe when some of these laws were being drafted, and maybe and certainly some of these judges were in law school, and maybe that helps explain some of the descriptively some of the outcome you're seeing as well. So I think that it's interesting your approach about criminalizing the similar conduct or having the same result for similar conduct, and in part because I think you are advocating for sort of a judicial solution, but whether it's judicial or legislative, you're really, I think, asking, and you can correct me if I'm wrong, but for sort of a federal definition of the requisite underlying criminal conduct. Is that right? You want to sort of define what the sort of problematic actions are?
Yeah. So I think that so many scholars have part of the problem with these statutes, again, whether you think it's a legislative issue or a judicial issue, is kind of the ambiguity of the statutes. So for example, one of the now infamous sentencing statutes is called the Armed Career Criminals Act. It goes by ACCA. And that's a statute that says, if you have a prior conviction for a violent felony, you can get a federal sentencing enhancement. And so the problem is, well, what state crimes qualify as these violent felonies? And so courts go off on, down that rabbit hole. And under the immigration statute, a common deportable offense is for an aggravated felony. And so, okay, well, now courts have to go down the rabbit hole of what is an aggravated felony. So
just to interrupt for a second, but just to be clear, aggravated felony is just not defined, right? That's why courts are sort of diving into going down these rabbit holes. You're saying is that what are the underlying conduct is just not specified by Congress in the statute, right?
Well, in some cases it's more defined than others. But for example, Congress will say something like, well, we think that burglaries are an aggravated felony, or we think burglaries are, a violent felony under one of these statutes. And that seems simple enough until you realize, right, the original problem that we've been raising is, well, 50 different states define burglary sometimes in very materially different ways. And so some scholars have said, well, the way you can fix that is just go back to Congress or have an agency just make a long list of all of the state crimes that would qualify as these aggravated felonies or these violent felonies under these statutes. And then you have a list that's, 100, 200 pages long of all of these state statutes. And then you can just check boxes. And I think that runs some political risk. That always runs the risk of legislators being wary of missing some important egregious offense that they didn't include, and then the democratic process wreaks havoc on their reelection. Which is why I think that Congress somewhat, as in many cases, kind of left this a little bit more vague for courts to fill in the holes, and that's what the courts did by creating this categorical approach, which it gets a little bit kind of into the details here, but let me do my best shot of trying to explain how courts kind of walk through this, and because I think that leads to some of my solutions in trying to simplify this process. So the burglary example, what federal courts do is they say, okay, well, Congress said burglary qualifies as one of these bad felonies that qualifies for this federal sentence or this federal consequence. So what we're going to do is we're going to figure out the federal definition of burglary. And we're going to consult all of these law books and dictionaries. So we're going to have the federal elements of burglary. We're going to put that on one side of the paper. And then we're going to figure out, okay, well, this person, this defendant before us, he committed a burglary in Missouri. So let's find out the elements of Missouri burglary, the 3-4 elements, and then let's match them up. We put those elements on two sides of the paper. Is Missouri burglary sufficiently similar, and does it match to the federal generic elements of burglary? If they match, then great. The Missouri burglary counts as one of these felonies that can trigger this federal consequence. If the elements of Missouri burglary do not match, then this cannot count as, going towards this federal sentence. So and that's where we run into the issues of, well, Missouri has these 4 elements for burglary. Iowa has these 3. So if you committed this burglary in one of these jurisdictions, one of them may match with the federal definitions, and that means you're deported. One of them may not match, and that means, pray to whatever God you believe in and thank them, because that means you are not deported. Not based on the actual conduct that may make you, dangerous, or that may make you a recidivist or whatever, but simply based on where you happen to commit that offense based on that state's elements of the crime.
Can you say more about that? So what I'm understanding is that, let's say the federal burglary statute has elements 1, 2, and 3. Iowa's has elements 1, 2, and 4, and Missouri's has 1, 2, 3, and 4. And so my understanding is that the Missouri, the second one that has, an extra element but satisfies all 3 elements of the federal statute, that would be, a sufficient match, and therefore you'd get the federal enhancement. But because Iowa defines burglary as 1, 2, 4 and leaves out 3, that in Iowa you would not get the federal enhancement. Is that right?
Yeah. So that's right. It really comes down to the federal courts burning a lot of paper and shockingly a lot of time. Because you would be shocked in how much judges complain about this, which is kind of another section of my paper, of judges saying how inefficient this process is. But so it comes down to figuring out what are the federal elements, figuring out what are the state elements, and then playing a matching game. And if they match, great. If they don't match, doesn't count. And so the Iowa burglar would not receive that federal punishment. The Missouri burglar would.
But so that's, though, right. So in my example, I guess the Iowa burglar did 1, 2, and 4 and didn't do 3. But for your example, for it to have this sort of effect of sort of seeming sort of unfair, it has to be that the Iowa burglar did 1, 2, 3, and 4 as well, right? Because the conduct has to be the same in Iowa versus in Missouri. And so, what is it that I'm sort of missing here? That so it's just, is it because the person isn't convicted of this, or there's no evidence of this third element? It doesn't get brought out at trial, right? Why is, let me put it differently. Why is this process so tedious for judges? Because I'm thinking, this ACCA has defined burglary, I think you said, as sort of a problem for a long time. And so I would think that, like, figuring out what is the federal definition of burglary, like that wouldn't take all that much time, because they've been doing it for years and years already. And so what is so time consuming about this for judges?
Yeah. So I'm glad you brought that up, because I should clarify. I should clarify this point that under the categorical approach, conduct does not matter. Judges complain about this as well. Judges are not allowed. They are specifically prohibited from looking at the actual conduct of what the Iowa burglar did. Mm. They cannot look at the criminal record. All they can look at is the Iowa statute of, I'll throw out a random number, statute 108.3. What are the statutory elements? That's all they can look at. So, and many judges have complained, somewhat along the same lines that I am, kind of bringing to light in this paper, that just seems, it seems odd that you wouldn't allow a judge to look at the actual criminal conduct when determining this federal punishment. So it's not a matter of, whether or not this fact was brought up at trial or there was evidentiary issues. It's just a matter of judges are only allowed to look at the state elements, they're not allowed to dig deeper into the actual conduct, which understandably many judges are not a big fan of. But the second part of your question, which is also important, is what is making this so time consuming? Where one judge went as far as to say it's one of the most taxing statutes that the federal judiciary has to deal with, talking about ACCA and talking about how to apply the categorical approach. So you're right when it comes to determining the federal definition of a crime. So there have been many cases on burglary, and the Supreme Court gave a definition of burglary, so that's the federal definition, and all federal courts follow that. Now that those definitions aren't always readily available for other crimes, but once a federal court says it, especially the Supreme Court, great, we can all be on the same page. Now, when you start to try to figure out the state elements, this is where we start going down a rabbit hole of increasing complexity based on many decisions of the Supreme Court over the past 20 or so years. So when trying to figure out what are the state elements, so you can look at the statute of that state, and you also have to distinguish between what are actual statutory elements and what are the mere means that a statute may define. So if a statute says you have to commit a burglary in some type of structure, that could be an element. But if a statute goes on and places a comma and says you could burgle a structure, you could burgle a house, you could burgle a car, or you could burgle an airplane, courts have said, well, wait a second, those aren't separate elements. Those are separate means of fulfilling the one element of burglaring a structure. These are just different types of structures you could burgle. And so courts have to really go in with a scalpel to figure out, well, is this statute listing different elements, or is this statute just listing different factual means to fulfill one of the elements? And so courts, burn a lot of paper doing that. And then there's also another kind of level of complexity, which is divisibility, what the courts call divisibility. So again, if we're looking at the state statute, there are some states, God bless them, that define statutes very oddly and define these crimes very oddly. And what they will do is in one statute, they will list alternate elements. So they'll say, here's one way you could be, guilty of the crime, or here's another set of elements that you could be guilty of the crime. So courts have to figure out, wait a second, one of these alternatives fits the federal definition, one of these alternatives does not. So now we have to figure out which one of these alternates the defendant was convicted of. So now we need to do a modified categorical approach, and this kind of goes down another rabbit hole. And judges don't know all the time because they're very smart people, but they're not experts in these state laws. Are these elements versus means? Or is this divisible? Do we have to look at the record? And when do these different things trigger? And that has created a lot of complexity in trying to parse out the differences of these state laws. There are a lot of judges who have gone on the record in dissents, in concurrences, basically saying we disagree with this approach. We think it's inefficient. We think it taxes judicial economy, but we respect precedent, and so we will follow this approach, even though they don't like it. So they are good soldiers in that sense.
So, all right. So judges don't like it. The Supreme Court keeps weighing in. I think you said 13 times over the last 20 or so years. And I think in the paper you suggest that they perhaps are making it worse and not better, but certainly are keep diving back into it to try to fix it. So can you talk a little bit about how to fix it? Because I feel like earlier you suggested that although perhaps Congress created this problem by drafting these statutes the way they did, that the categorical approach is a judicial approach to this, and therefore you place some of the blame on courts. But you also, despite blaming the courts for creating this muddle, I think have suggested that courts are going to solve the problem as well.
Yes. So I think that from a standpoint of efficiency, I think that courts are in the best position. And really, at this point, it has to be the Supreme Court, because they, like you said, and like I've said in my paper, this is the gift that keeps on giving, because it seems like every term. So last term, there were 3 cases on ACCA and some of the different applications of the categorical approach. This term, there have been 2, and that doesn't seem to be slowing down anytime soon. So let's talk about kind of some of the different ways that maybe the court could step in and do a little course correction here, because asking Congress to do this, good luck getting Congress to do anything these days. And so, the court kind of spilt the milk. And I think they're in the best position to wipe it up and do a little course correction. And they're certainly within their power to do so. So one of the things that I suggested is to pivot from an elements-based approach where you're comparing elements from the federal to the state elements, to pivot from that to a conduct-based approach. So what that would be is you would still have that first step. You determine, Congress said burglary counts, so the courts are going to determine what does burglary mean for us. All right, let's get the federal definition of burglary. And if this offender committed a burglary in Iowa, let's look at his or her conduct. What did they actually do? Did they burgle the building? Did they go in there with a weapon and so on? And what did they take? And so the burglar in Iowa, who did the same thing as the burglar in Missouri, they would be punished the same. They would get the same outcome if we're comparing conduct, as opposed to comparing the different state elements. And what I think that does, and no solution is perfect, but what I think that does is it gets us closer to the goal of uniformity. If uniformity is important to the federal system, I think that is the best way that a court can quickly pivot, save a little bit of face, and just say, we're going to focus more on the conduct here so that we can make sure we're punishing similar conduct similarly. And there's also been a discussion in the literature about, which you teased at before as well, is this type of uniformity even possible? And some people are quite comfortable with non-uniformity. And that is also an option. But my point is, if you're going to pivot away from uniformity, then let's just call this what it is. and admit that you are allowing disparate sentencing based on what I see as an irrelevant uh, characteristic of a criminal's past, which is basically where they happen to commit the crime. So, we can pivot away from the elements based approach to get closer to uniformity. Or, another option is just to say uniformity is just too difficult. Let's just call it what it is and let's pivot away from uniformity and come up with some other justifications, primarily that, yeah, this is a federal system. And yeah, we do accept that state definitions have impact on federal law. So let's accept that, and let's kind of coalesce a doctrine that accepts that, as opposed to trying to marry the two, trying to say we have a uniform system, but we're going to treat people differently.
Thank you. No, I think I certainly come out on that side myself. Well, Sheldon, this has been great, and I find that on an area that I really knew nothing about, I have a million more questions that I would like to ask, but we're sort of starting to run out of time, and so I will let people who want to sort of dig in more read the article, the categorical non-uniformity. Instead, I'll just sort of leave off by asking you: is there anything else you'd like to talk about or say before we end the show?
Well, I just want to thank you for the opportunity, and this is such an important issue, especially in our time where we are really asking difficult questions as a society when it comes to rethinking criminal punishment, decarceration, as well as immigration reform. And so, this is just kind of one contribution that I hope gets people thinking about that, as we do think about more systemic changes in how we treat criminal offenders, and also how we treat non-citizens in some really life-changing and impactful punishments that we as the people and that the government hand out. So very excited about this piece. I'm happy to contribute my small part of this, and I look forward to contributing more to this conversation.
Thank you. All right. Well, actually, before I wrap up, is the piece on SSRN, is it out for publication? For offers? Is it available for people to read if they'd like?
Yes. So you can find it on my SSRN page. I won't try to spell out the link, but
we'll put it in the show notes so people.
Yes, and I'm very fortunate and thrilled to that I am working to get it published, and it's going to be appearing in the Columbia Law Review in, I believe, the November issue. So very excited to work with the folks at Columbia for that.
That's a great result. All right. Thank you very much, Sheldon. Tonight, my guest has been Sheldon Evans, an assistant professor at St. John's University School of Law, talking about his article, "The Categorical Non-Uniformity," not the categorical non-uniformity. And the link to the article will be in the show notes. It's available on SSRN. Sheldon, thanks so much for joining me.
Thanks, Matt.
Take care.
Take care. Yep.
logic all sublime, he will achieve in time to let the punishment fit the crime, the punishment fit the crime, and make each prisoner pen willingly represent a source of innocent merriment, of innocent merriment. Let the punishment fit, let the punishment fit, let the punishment fit the crime, the crime, the crime.